there's ever been a question of
Good morning, boys and girls. Friends, lovers, children of all ages. We welcome you to another episode of Cut the Plastic. In today's episode, we're going to be listening to the Green Mountain Water and Sanitation District's last public meeting.
Adrian, you're still muted.
At this last public meeting,
this is a notice of a special meeting of the Green Mountain Water and Sanitation District.
In this Green Mountain and Sanitation District, you are going to enjoy some outrageous public commentary.
County of Jefferson, State of Colorado will hold a
the entire meeting
at 6 p.m.
can be found
Tuesday, May 4th, 2021
at this link
13919
right
West
here.
Utah Avenue, Lakewood, Colorado 80228. This meeting will be held.
This
for
is the
purpose
website.
of conducting such business as may come before the board. This meeting is open to the public. This is a virtual meeting. Jefferson County Public Health COVID Enforcement Division has provided direction for public indoor meetings since counties were allowed to enforce their own COVID dials, in effect as of April 16th, 2021. On April 17th, 2021, Jeffco had moved to a level blue, specifically for Jefferson County. Therefore, the district will offer the means of participating in this meeting by a video conference call. To attend, please go to https://zoom.us/J99390363-271 or call 669-900-6833 and enter the meeting ID. The meeting ID is 993-9036-3271. To troubleshoot issues with connection at the time of the meeting, please follow this link, https://support.zoom.us/hc/en-us
Good morning, Mr. Whitney.
/sections/
I'm going to turn the volume down on that for a second while I explain, as some of you are joining us, what's going on. Many of you have listened to public meetings. Many of you have heard about sunshine laws, but maybe you don't understand them. Maybe you don't understand the role of the public in making decisions. So I want to give you a little background information here while they do the intro. The Green Mountain Water and Sanitation District is a water and sanitation district in Green Mountain, Lakewood, Colorado. The water district owns and operates the utilities, the water cleaning, the sanitation, all the things that it's responsible for its residents.
And now for reading of the agenda.
It is a public-owned, taxpayer-funded utility.
Members here. Adrian Hannigan.
They're reading minutes here, and immediately as we enter this meeting, you're going to find that...
can you unmute yourselves, please?
Karen Morgan here.
They're doing roll call right now.
Rhonda?
Alex.
Peters? Okay, it looks like we have a quorum. Thank you very much. Now, item number 2 on the agenda, I declare that we have a quorum. All board members are present. So for directors' matters and disclosure matters, does anyone have anything to disclose? No? Nothing? Okay, so I'm going to move on to approval of additions or deletions from the agenda.
Here's where it gets good.
Anything?
No items.
Okay, thank you very much. Okay, so item number 4 is public comment, which is limited to 5 minutes per person. Members Members of the public wishing to address the board on agenda items or during the public comment period are asked to indicate the agenda item number. Members of the public will then be recognized by the board as each agenda item is undertaken. So I think what we can do is we can have public comment at the beginning, and as specified here, it says members of the public can be recognized by the board as each agenda item is undertaken, but we can't go on and on for forever. So, I think that we, as an agenda item is taken, we can just cut it short and just go through and get people's opinion and things like that.
Can I see, I'm sorry to interrupt, but can I see a new motion for that? I did motion to keep public comment to item number 4 on the agenda at the last meeting. So that is probably a holdover from previous agendas, but that was a motion made and passed.
Okay, I'm going to have to tell you that motion is out of order. Pursuant to the Sunshine Law and Title 32 and how the agenda was properly noticed. This is how the agenda was properly noticed. It is listed here. So you may have tried to change that in the past, but this doesn't allow us to do that. So what you have to do is we have to acknowledge that motion was out of order. As per the Sunshine Law, you published this. This was published.
Do you hear that? Do you hear that?
Please don't interrupt me.
It says, you published this per the Sunshine Law. You must follow this. This is the public record. We have public comment. This is why, friends, I am encouraging you to continue on with your workday. Turn the volume up, and for the next half hour to 45 minutes, enjoy this royal ass chewing that the members of the community are going to give their public board members.
Thank you. Now, you please talk. Okay?
I'm not, are we sure we're done and I can go?
Please do.
Can you explain to me how a motion legally passed by the board is a violation of the Sunshine Law? So what you're saying now is that it was on the agenda, and I'm saying that probably it was a holdover and we should take that out. We did already have a motion passed that we would keep that to section 4 of the agenda. So that was passed in the last meeting. So
But you have it here.
I don't
It
see.
is written.
Yeah, I understand. So there is a conflict between what is there and what
Yes.
was legally passed by the board.
Yes.
So if perhaps I'm suggesting that was a mistake. You're saying that agenda should take precedence over the motion of the board.
Yes.
So perhaps you'd like to make a motion to keep that agenda with more public comment so that I don't see how else to reconcile that, because it was made and passed.
The thing is that, okay, Joe, Joe would like to speak. Please speak.
Yeah, I just want to point out that motion was specific to the last meeting. So, I don't think there's holdover motions from meeting to meeting when it was specific for the last meeting. That would
You would be correct. In the last meeting that you attended, they were specific to the meeting, but the one that I passed last time was for all future meetings, so that we don't have to do this every meeting.
Well, I think if the agenda, okay, I'm sorry, I didn't hear the last meeting, so you're probably right about that, Karen. But I do think that if the agenda has something on it, then, in order to move to change that. So I'm sorry, I didn't understand that the last meeting was a different motion. So I was talking about the meeting before that, I guess.
But the thing is that you've published this and you've sent this out to the public. And what do you expect? The people who are coming to this meeting are expecting, it is an expectation of the public to be able to contribute to public comment, as specified here. This is I'm sorry, I can't change this.
We can go with the motions that have been made. We can acknowledge the fact that that motion was made and it was probably a mistake. We can make a new motion to keep it going as we have been so that we don't get interrupted. There are lots of things that we can be doing, including acknowledging the fact that we can make this motion at any time and that is not a problem because it wasn't on the agenda. I don't understand why this is the people who come to these meetings are very active in government. I mean, this is a little water board district. Everybody here is very active and involved, and I appreciate that. I cannot believe that nobody here knows how city council is run with limited times on things. So this isn't unusual to be doing, and given the way that past board meetings have been going, I'm not understanding the problem, I guess.
So this is clearly, I will state this again. So your motion is out of order. This is a violation of the Sunshine Law, and this is how the agenda was properly noticed. It was provided for people, and with the expectation that they would be able to comment. And I think that it is unfair to deviate from that. And I would beg your indulgence. Let people talk now. Just let them talk.
Sure,
And don't fight this.
I absolutely agree.
Okay,
I absolutely
well,
agree.
thank you.
This is public comment, period. This is number 4.
Yes.
But
So
there
allow
is
them.
no other comment, period, per the previous motion.
Okay, what I would say is what this says in the agenda is they will be recognized by the board as each agenda item is undertaken. So then if you want to change that in the next board meeting, please be my guest, but it is published here. And so to change it right now is a violation of the Sunshine Law. And so I am going to stand on that, and I would like to move on, if I could. Excuse me, please.
Before you move on, I need to put on the record that there is no violation of the Sunshine Law for motions duly passed by the board. That's actually not standing up for the motions of the board is a violation of the board bylaws and your duties as president. So this is what we need to be doing. If that's what you would like to do,
Perhaps
But this is-
we can settle this question later, and we could proceed with the meeting.
I've
Okay?
stated it's off the record. Let's hear the people, I guess.
Okay, so I would like to ask people if they would like to address the board at this time.
You can
Is
use
there
the
anyone?
raise hand function, or
You
if
need
you're
to
on a
use-
telephone call, you can
Yes.
use *9. We'll answer
Mhm.
the questions in the order that they come in. So the raise hand function will place people in order, and we'll recognize people in that order.
So Jesse, can you take care of that? You'd be, good at that, I think.
Yeah,
Okay.
I can unmute people and recognize them as the raise hands.
Yes,
come up,
okay,
no
thank you.
problem.
Also, Jesse, I'm sorry, I don't know I just wonder, how do you use the raise hand function? I don't.
On the bottom bar, there's a little thing called reactions with a smiley face and a plus sign.
Okay,
And then if you select that, then there's a big bar along the bottom that says raise
Oh.
hand.
yeah, I gotcha. Thank you.
I
Okay.
think we have someone, Kathleen.
Okay,
and
Kathleen,
Devin.
you're unmuted.
I just have one question. Could you explain what the Sunshine Law is to me, since I have no idea what that is? Thank you.
Okay, basically the Sunshine Law provides the public with transparency. For example, we cannot meet in secret, and we have to have transparency. I think a very good explanation of the Sunshine Law, I would like to defer to Joe Timmons, if I might.
Right, yeah, the Sunshine Law is actually the Colorado Sunshine Law was patterned after the Florida Sunshine Law. And I have a feeling they called it the Sunshine Law because that's called the Sunshine State, Florida is. But our sunshine law is patterned after the Florida sunshine law. It goes back to like the 1960s and 70s. Before that, there were kind of specific little statutes that applied to each board, but the sunshine law was a way that the whole state started to regulate public bodies, public entities, and how they do business. And the idea is that the business of a public entity is public business, and the business should be done in public. So they should discuss business, discuss policy, all in public for the benefit of the public, with transparency for the public to understand how decisions get made. So that's really the kind of foundation of the Sunshine Law. There's the Open Meetings Act, there's the Open Records Act. Those are all part of the Sunshine Law. They require that meetings be held and be open. They require that public records be open to the public. These are just parts of the Sunshine Law.
Okay, Kathleen, does that answer your question? Kathleen? Okay, I guess, Jesse, who else was next? Was Devin?
Devin Neal is up next.
Thank you.
Devin, you're unmuted.
I'm trying to start the video. Hold on. Start video, okay. I simply want to ask, the way that I understood what's happening tonight, each issue will go forward and then there will be an opportunity to comment on each issue. Did I correctly interpret?
As listed in the public comment, it said that members of the public will then be recognized by the board as each agenda item is undertaken. And once something like this is in writing and it's published, I think that, as a public body, we need to be held to what we publish and what we put out.
I think it's very helpful, and I will just wait until we go through the items. I think it's incredibly helpful, and I thank you very much for your organization.
Okay. Next is, who's next, Jesse? Oh, Brenda?
Rita's up next.
Oh, Rita, okay.
Rita, you're unmuted. Go ahead.
So I want to protest Director Morgan's change of an agenda item tonight to limit public comment, because this is in direct contrast to the plain language of the agenda that was posted on Friday. And the purpose of posting notice and an agenda is to make sure that the public knows how to conduct themselves and operate at a meeting. And if Director Morgan understands City Council, she would also understand that there is a consent agenda where the public can and does comment on agenda items for second and sometimes third readings in certain cities. At the last meeting, one board director attempted to motion for a new agenda item. And at this time, at the last meeting, Director Morgan stated, quote, "There is nothing to say that we cannot add agenda items," unquote. Director Morgan, you have defended at multiple meetings now your right to add agenda items at will to public meetings. You swore an oath of office to uphold Colorado law, and yet you do not know Colorado law. There is no statute that exempts special districts from Title 24 of the Colorado Sunshine Law. The statute and controlling case law is clear. If you know or intend for a particular action to be proposed at a meeting, it is your legal obligation to have the item included and defined on the agenda pursuant to fair notice. I am summarizing directly from the controlling Colorado Court of Appeals case. Multiple board members knew that Director Plotkin was going to propose termination of our council, and yet these board members did not provide that very critical action item for the agenda. This is a violation of an oath to preserve the public trust. There are only narrow exceptions to not posting notice in case law, such as an emergency meeting or unforeseen developments or critically urgent items, none of which are the case here. Green Mountain would not even remotely meet the standard in a courtroom of any kind of exemption for full and fair notice. I understand now that our district manager is claiming in an email that I was forwarded today that a certain person at the Special District Association has told him in a training that, quote, "Yes, a board member can do that,"
referring to the last minute agenda items. I would like to ask that the board chairman or legal counsel of Green Mountain Water follow up directly with the individual he cites to make sure Mr. Krupkowski understands and his understanding was accurate from his training. I am unclear as to how Mr. Krupkowski is relying on a legal interpretation of the law without confirming it with district counsel. In a review of the agenda tonight, I see that the board has somehow already received, quote, engagement letters regarding evidently a solicitation for district legal counsel. Please explain to me, board members, how you solicited these engagement offers without any board discussion. I would like to know which firms and individuals these come from, without anything whatsoever meeting. Lack of
Can't hear you.
equal opportunity to all candidates in a future selection. I would like to know if these current candidates have been pre-screened and by whom. Questions, who developed the questions for them? How did these candidates know that the district was considering new counsel? And how long has this been deliberated without board discussion? Which board directors knew engaged with it? I believe the public needs to know tonight the backstory to these current candidates and the letters before proceeding to any kind of decision on this matter. Thank you.
Okay, thank you. Who's next?
Next is Christopher Arlen. Mr. Arlen, you're unmuted.
Good evening. And if I can help you with that little conundrum that Director Morgan was talking about, the solution is to make sure that that's not the way that the next agenda is worded. It's just that simple. Directors, my name for the record is Christopher Arlen. I'm a homeowner at 11435 West Mississippi Avenue. I am an elected to the district, and I'm here tonight on my own accord and on my own behalf. I state this because there seems to be some confusion about my involvement in the affairs of the Green Mountain Water and Sanitation District. Excuse me. I am not part of any mob. I'm not an insurrectionist. I am not merely a supporter of Director Hannigan. I have not lost count of the different ways I can express disdain, disrespect, or a lack of knowledge of the issues before the board. And I am not an attack dog. At best, these characterizations are tone deaf and ignorant. At worst, they are racist dog whistles. Nonetheless, they are all untruths designed to marginalize so that the merits of my arguments are deflected. I've seen it before, and I'm sure that I'll see it again, but that's another matter. My complaint is against the board as a body. I've met all of you, and I found you all to be lovely people with complex thoughts and a strong articulation of your ideals. And I truly enjoyed meeting you. But when you come together in these meetings, the people that I met disappear, and a particular nastiness takes over. And I don't need to be appointed judge to see this behavior. It's on display for all to see. And yes, I stand behind my assertion that you all squabble like children. But that's not because of me. That's because of you. And I still call for you all to do better because I know that you're better. In my observation, the majority on the board is working in service of one individual with goals that may not align with the best interest of the district or its electors. Ironically, Mr. Henderson has never lived within the district, and he's never been an elector, and he has many agendas that are clearly personal and unrelated to the district. He has co-opted the Green Mountain Water and Sanitation District and its resources in service of his own petty grievances, which are quite transparent to those who read the Rooney Valley blog. And even worse, he's corrupted this board. In a recent blog post, Mr. Henderson acknowledged that he's not counsel to the district. He goes further and he states that you all only call him a consultant so that he can participate in executive sessions. This is a fraud, and those sessions are technically illegal. But beyond the illegal executive sessions, members of this board dance around the Open Meeting Act by playing telephone, by talking only two at a time. And there's no pretense about this. More than one director has disclosed that this is how they communicate. The orchestration among the director clearly demonstrates that there's a level of coordination. However, as I've stated before, this is unethical and potentially unlawful. And there can be no doubt to those who observe these meetings that there's a great deal of coordination out of the public view. One of the distinctions of a special district is that all business is to be conducted in the public. This is how the board is accountable to the electors. And there seems to be no accountability here. This is why many of the electors disrupted last week's meeting and this board was tempting to fire Joe Timmons. Mr. Henderson is right. I have no more authority than any other non-director. I have no illusions that I have been elected to sit on this board. But what he doesn't appreciate is the power of a voice. I use my voice to speak out against what I perceive to be a great injustice that had potentially dire consequences unless it was disrupted. So that's what I did, proudly. I disrupted the process. But to be clear, Mr. Henderson is also unelected. Mr. Henderson is not a resident of the district or even the state. He is not and has never been an elector to the district, and he, like me, has not been elected to serve. I, however, am a resident and an elector to the district. And if there's an outside agitator here, it's Mr. Henderson and his followers who reside outside of the district and those who are not electors. Of course, I support Adrian. She's my friend and I adore her. But I have no desire to personally persecute members of the board that I disagree with. I actually think that disagreement is a value that lends itself to effective leadership. But to imply that my views are not my own or that I'm simply trying to defend her is unfounded. Ask her. She'll tell you I give her plenty of feedback. And I'm quite clear-eyed about my observations. I have been a part of and have led countless organizations, community-led processes, and statewide planning groups. I've seen organizational dysfunction in its many forms, and contrary to Mr. Henderson's assertions, I am quite knowledgeable in this area. So the question I leave you with tonight is this. Does this board serve the electors of the district, or does it work in service of Mr. Henderson? Mr. Henderson tips his hands often and he projects terribly. What he calls an insatiable appetite for trying to undermine other board members in front of the plaintiffs is truly the community rising up to prevent you from doing the same. He states that our actions are antithetical to defending the board in litigation. But the board isn't the defendant. The district is the defendant. Board members are only defendants to the degree that they create individual exposure. Perhaps this explains the confusing proposed bylaw amendment requiring malfeasance insurance seeking to cover these public officials, you, from wrongdoing. Perhaps you're more aware of what you're doing than I would have thought. And I will close with this. I encourage you to choose whom you are working in service of. Hopefully the goodness that I saw in you individually will prevail within the group, and Green Mountain Water and Sanitation District can return to doing business on behalf of the electors. I thank you for your time and your attention.
Thank you. Okay, next.
Brenda Bronson, you are unmuted. Go ahead.
Thank you. I am Brenda Bronson. My address is 11063 West Ohio Place. I'm electorate of the district, and I'm on the committee who will recall Alex Plotkin, Karen Morgan, and Jeff Baker if they continue to hurt our district. I didn't plan to make a public comment, but a friend of mine wrote a wonderful letter, and I'm going to read it into this general public comment. I didn't plan to make one right now, but because he couldn't be on the call tonight, I'm going to read a letter written to the board by Bill Furman, who is also an electorate of the district and lives within the Green Mountain Water Board. He wrote this letter April 27th. Dear Green Mountain Water and Sanitary District directors, as a customer of Green Mountain Water and the Sanitation District, I'm troubled by the fact that the districts and our fees are being used by people outside our districts, in some cases outside the state, to fight their battles. John Henderson, who did not previously live in the district and now who does not even live in the state, may have a personal crusade against developers, but our district should not pay for it. This board has a responsibility to protect the district and its ability to function. Part of that ability to function is to remain financially solvent. You have a fiduciary responsibility to make the choices that best protect the interests of the district, not anti-development agendas, and certainly not anti-metro district agendas of individuals outside the district. Now, I don't want to suggest I know what's the best course for the district is, but after the district went through 2 attorneys before arriving at the current representation, I will assume it was a painstaking process and one that was thoughtful and meant to protect the interests of the district. So take the advice of your attorney, Joe Timmons, as to what is the best course of action regarding the litigation before you. If you are voting based on your personal agendas or that of John Henderson's, rather than the benefit of the district, you are not serving the people of this district. Finally, and certainly the most important point I wish to make, please sever ties with outside agitators who have well-known agendas meant to use our district to carry on their own crusades against developers and metro districts. You get what you pay for when you take free legal advice from a lawyer that is not now, nor has ever been in our district, and who will not suffer the consequences of negative outcomes for our district. Start serving the people of your district and accept advice from the experts you have hired and paid to protect our water districts. Regards, Bill Furman, 814 Lewis Street, Lakewood, Colorado.
Okay, thank you. The next,
Kathy Odenwaller, you are unmuted. Go ahead.
Okay. I'm going to start by making a few comments to Alex. And I don't see him on here, but Alex, are you aware that the word secretary on the website is after your, and I imagine you should be, because that's the job I understand you're supposed to be doing. And I'd like to know, do you actually know what a secretary does? That's rhetorical, of course, I'll answer that. A secretary keeps records, not destroys them, keeps them. And a secretary keeps the minutes of the meeting. And it concerns me that you have very clearly demonstrated, as well as stated in no uncertain terms, that you're not capable of performing those duties. So why in the world would you campaign and volunteer to do this job? And didn't you take an oath of office to do this job? So I'm not understanding exactly what it is you do for the board. You come to the meetings very unhappy, very angry, and very contentious towards the public. You don't want to answer questions. You don't want public comments. The only contributions that I've witnessed at these meetings have been very contentious and chronic complaining about others. It's obvious you don't want to be at these meetings. So, quite frankly, I want you to leave the board. I want you to resign. I see nothing productive resulting from you continuing on the board. And Karen, I'd like you to resign too. I really, really am uncomfortable with the way you treat the public, your attitude towards the public, and your lack of transparency. And although you are not even listed on the website as the treasurer, my understanding is that is your official responsibility to the board, to the district, and to the stakeholders. But every meeting I've attended, you show up at the meetings, you're unprepared, you complain that you are very concerned about the budget. Meanwhile, you're out there hiring other attorneys, and you don't have the numbers in front of you every single time. And I don't understand that, because you're at home. Can't you just get up and get them? So I am not really feeling that you are taking your oath of office seriously either. But more concerning than that, for me, is that you're on this board, but I honestly do not see where you're serving. You don't want the public, like Alex, both of you are very contentious towards the public. You want no public comments. You want to do things without any transparency. And, you know, the disrespect that you have towards the public, you know, proves that you have no interest at all. You don't give a damn about the public or about the district. So I don't see where you're serving the best interest of Green Mountain. You know, I tell you, sitting through these meetings, they become just at the beginning of this meeting, it becomes very uncomfortable. Immediately you start arguing, you want to make a motion, no public comments, nobody, you want nothing productive, it seems, to come out of the meetings. Last but not least, Jeff, I would also like you to resign. Well, I definitely have never experienced you to be anything but respectful and show polity, and I've never experienced any unprofessionalism from you. You are the vice president of this board, and your job is basically to assist and support the president. I have not experienced that at all. I have experienced, you know, you support the contentious behavior, the unprofessional behavior, the disrespectful behavior of the other two members that I'm complaining about, obviously. And while you may not do the dirty work, you do seem to support that. So I just don't see how continuing on is productive. You know, the lack of unity is one thing, but, you know, I think we're, you know, beyond that. The whole point of a board is a team, and you work together, you work collectively, you collaborate. And I just don't experience that in any of the meetings that I have attended. So that's pretty much my time, and that's all I have to say for tonight. I really do hope you do yourself a favor and the district and resign. Thank you.
Okay, Mr. Davenport, there is someone here who wishes to speak. Mr. Mike. So he says he can't raise his hand or something. So I guess what we can do is we can ask him to unmute. Is that acceptable?
Mike Mueller?
Yes.
Okay.
Okay.
Mike, you're unmuted. If you need to, it's on the bottom. It's on the reactions. It's like the little silly smiley face.
Yeah, but when I opened up the box, the little hand that was there just disappeared.
Oh, no. Okay. Well, yeah, if we'll take a look at that. Also, if any members of the public on the phone need to raise their hand, the function is *9. Go ahead, Mike.
Okay. I have a couple of problems. One is that I put in a quarter request 2 weeks ago, which now makes it that you guys have broken the law and not getting me my quarter request back. I was also informed by one of the employees that no quarter requests by order of one of the directors are to be filled during this time. Now, I don't know what this time is, but I'd like to know who the director was that told them not to fill any quarter requests. Mr. Gregg, you are responsible to get those quarter requests out. Alex Plotkin, as secretary, you are responsible to get those quarter requests out. You have failed, both of you. The next step will be go to the state and file suit against you. And you two will be on it personally. So I expect to have that quarter request in my hot little hand no later than Thursday at 5 o'clock. Do we understand each other? Can I see some heads rattling? Yes, no, yes, no?
Okay, that's no response, please. So anyway.
Well, they don't have to respond. They just have to rattle their heads.
All right, okay.
Next, I tried to call in there. Nobody answers the phones. Oh, I tried to get Greg's phone. He didn't answer his phone. I asked for a call back. He won't call back. What kind of public service or community service or customer service is this? This is ridiculous. The whole district is going to crap since Greg and this board has gotten together. Next, it took 1.5 years for the city of Lakewood to get a new lawyer. 1.5 years. of checking out 13 different lawyers. You can do it in one night? That is flippin' amazing without any public comment. I don't think this is good. This should not be. What is wrong with public comment? What is wrong with us running our district? What is wrong with you listening to us? Does anybody understand this? You three gotta go. Alex, I'm asking for your resignation tonight because you're worthless. You're worse than worthless. You're a troublemaker.
Please, change your tone, please. Thank you.
Excuse me, my 5 minutes. Now you owe me 30 seconds. You owe me 30 seconds because you interrupted me. Now we're talking. So no. So I'm asking for you to resign. We have a big job to do. You are trouble. You are hurting the process. Karen, I cannot believe the garbage that comes out of your mouth. You listen to the people that own this district. You don't own it. We own it. All of us own it. Not you. You don't get to make the rules. We do. That's called sunshine. Sunshine means that the sunlight comes in and it cleans everything up. It disinfects everything. Well, you guys are trying to turn off the light. Open it back up. Thank you.
Okay, thank you very much. Is there any further public comment? Shall we proceed with the agenda? Anyone else?
If anyone
Yes?
on the phone would like to make a comment, the
Star
function
9,
is star
yes.
9.
Mm-hmm. Thank you for advocating for them, Jesse. Phone people? Anyone? Okay, at that point, I will close item number 4, public comment. And what I would like to do is have some decorum regarding questions. I think that the item number 5, directors matters, I would like to limit what people say to 5 minutes, and I'm going to be trying to time people as best I can. So item number 5 is directors matters. Item number A is discussion and adoption of the framework under which the district will receive legal guidance and representation. Item I, representation and guidance pertaining to ongoing litigation. Representation and guidance pertaining to Title 32 matters. Example, contract interpretation and conduct of regular meetings under the provisions of Title 32. Non-litigation related core review. Assistance with other routine Title 32 issues requiring legal input. And to discuss the engagement need of RFP of firms who have proffered, I'm not familiar with that word, engagement letters. And item B is discussion of CDM Smith's report on Green Mountain Water's wastewater system capacities review of Merrick. So I open up to item number A. Okay, whoever wrote this, whichever director wrote this, can you please comment on this, please? So, discussion and adoption of the framework under which the district will receive legal guidance and representation. Nobody's going to talk about that? Okay. Joe, do you know what's going on? I am completely clueless. Okay. You know, what sort of framework are you looking at? Okay, there is a question from the public. I've heard nothing from the board of directors regarding this matter. Scott?
I guess I would like to unmute.
Okay. Okay, all right. Okay, unmute.
Thank you. Director Hannigan, I believe this was was put on in reaction or as a as a response to the discussion that happened last week.
Okay.
So I think that's why it was on there.
All right. Okay. So shall I? Is there any clarification? Shall I go to Miss Neal? Is that acceptable, Mr. Gessler? Anybody else would like to comment? Yes.
Adrian, Devin, Neil put their hand down.
Oh, she did. Okay. All right. Okay. Go ahead. So, who wrote this Directors Matters section? Who wrote this?
Scott, you're unmuted. I'm going to go ahead and just set you so you can unmute yourself.
Okay.
Oh, thank you.
Adrian, I wrote the agenda based on what I thought I heard coming out of last week's meeting in discussions with Scott and all of you. And I got it out to all of you on Wednesday as a draft.
Okay.
And received no comments to change it, so that's what was posted.
Okay, that's fine.
On Friday. So this was based on what I believe the board wanted to talk about this week, hence the reason for this meeting.
Okay. All right. Okay, so the board wants to talk about this. Okay, representation and guidance pertaining to ongoing litigation. All right. Mr. Gessler, can you help us out with this?
Certainly. My understanding is that from last week that there were several board members who were interested in looking at a new general counsel for that particular role, and that Ms. Timmons and myself would be focused strictly on litigation matters. I mean, my focus in general is just on litigation matters, although, I mean, there were a few other items that happened last week. And so I think this was in response to that. And if I may say, I understand, you know, there was some informal outreach, and one member, and one law firm expressed some interest in this. I'll just tell the board right now, I did speak with that firm to gauge their interest. And we left the conversation that I was unsure of exactly what direction the board was going to take, and exactly what, if they decide to go forward with general counsel, you know, if that was going to be, you know, what type of process that was going to be exactly. So I can say there was one firm that at least expressed interest and is interested.
Who are they?
That's about the extent of it.
Who are they?
I forget the firm's full name. I spoke with a guy named David Shohet, Shohet, I believe his name is spelled. They apparently applied originally several years ago as one of the contenders for general counsel, and I think they remained interested in that. That's sort of the extent of those conversations, for what that's worth. But I would submit, I think the board, you know, at least based on last week's conversations, needs to decide whether they want a new general counsel. It seems as though there's a very strong consensus that Ms. Timmons and I would remain litigation counsel, and then if so, what process to follow. And I know Ms. Timmons and I have discussed the matter, and she may have some comments as well.
Okay. Can I move to there are two people asking questions about this. Yeah, I have some questions too. This is kind of a surprise to me. So, Mr. Davenport, could you allow Miss Neal to speak, and I'll set the timer for 5 minutes.
Sure.
Thank you.
You're unmuted. Go ahead.
Thank you. So I want to introduce myself to everyone. I'm sitting outside of my patio on this gorgeous evening. My name is Devin Neal. I am a personal injury trial lawyer. Adrian Hannigan reached out to me roughly 2 weeks ago after John Henderson and his crew, that's a polite word, attacked her and Joe Timmons. So I live in Solterra. I've dealt with John Henderson, and I have written quite the email string that is now part of the public record about this meeting and the actions of the 3 board members about whom there have been complaints lodged here today. Here's what you need to know about the general counsel position. So the general counsel position oversees the litigation. And what that means for Green Mountain, again, I want to make it very clear. I'm a personal injury lawyer. I do not represent and I do not live in Green Mountain. I live in Soltero. Our Fossil Ridge pays money to Green Mountain, and I get billed from Fossil Ridge what we pay to Green Mountain, okay? That's my only dog in the fight. But I want to explain what general counsel is to the public. General counsel oversees the litigation. General counsel makes the decision on whether a new IGA is entered into with the consultation of the board, right? So the board votes, but the general counsel makes that deliberative process. The reason why there's this whole, woohoo, we got to have new general counsel all of a sudden is because Joe took the amazing step of number one, first and foremost, figuring out how to get out of the contract, okay? Joe can explain this. It's very simple. Joe found how to get out of the contract. Yay. Now Green Mountain has a perfect negotiation stance to get a new IGA in place that benefits Green Mountain economically to the tune of, I think it was like $4.5 million to Green Mountain with virtually no downside because now Green Mountain has the upper hand. But John Henderson and his 3 board members about whom everybody's lodging complaints because they're basically his lackeys, doesn't want any development over on Green Mountain. Now, I have written an incredibly lengthy email string called the Come to Jesus meeting. I'm happy to forward it to anyone. There's a whole bunch of people who already had it. Ask all the board members, they had it. These people cannot answer common sense questions, but fundamentally, the reason why there's a discussion of new general counsel is John Henderson does not want Green Mountain to enter into a new IGA. So this is, the whole new counsel thing has nothing to do with Joe herself. It is John Henderson trying to prevent Green Mountain from entering a new IGA. So the whole new counsel thing is just a sham for the real underlying issue. If anybody has any questions, my email address is Devon, DEVON, at Neil Trial Law, NEILL, triallaw.com. I am sending in stuff as we are talking tonight, and will continue to do so. I hope that it will be made part of the public record. Thank you.
Okay, thank you very much. Can you unmute Brenda Bronson, please?
Rita had her hand up.
Oh, she did. Okay, I'm wrong. Thank you. Okay, go ahead, Rita.
Rita, you're
Yes.
unmuted. Go ahead.
Oh, thank you, Jesse. I guess really confused again about what's on the agenda. The agenda states that the district somehow evidently has engagement letters, plural, for candidates for this unwritten solicitation for a district council. How did that happen without this board authorizing the solicitation of engagement letters? I'm concerned because I don't know how you guys are going to proceed to hire somebody if you haven't afforded all your candidates the same opportunity to apply for this position in the proper procedure. If you've done, and now apparently somebody has interviewed them, and did the board authorize an interview process? When did this interview happen? So at the last meeting, okay, keep in mind, there's a record of what you guys did at the last meeting. You went into an unlawful executive session because it was not posted. Alex withdrew his motion after the executive session and stated, quote, "I will withdraw the motion and will suggest at the next meeting next Tuesday, we schedule a meeting for purposes of restructuring legal. The general inclination there is to retain a separate title 32 attorney or consultant or attorney to conduct the day-to-day business of the district, and to have the legal team, the outgoing litigation, be done by Mr. Gessler by direct engagement to the board and Ms. Timmons by direct engagement to the board. Did I recap that correctly, board members? Director Baker stated on the record, quote, "That's good." Director Rhonda Peters responded on the record, quote, "That sounds like what was discussed." So all you guys verified on the record that the board had deliberations and took positions in an executive session on this issue. And that executive session was not recorded by your attorney because you stated that you entered that executive session for the purpose of receiving legal advice. So I guess I don't understand. Who did you guys authorize in that executive session a decision? Because that is a violation of open meetings law. And if you did any deliberations in that, that should have been recorded by your attorney, because we can't now go back and look at what you guys talked about. So I want to understand, you're only permitted not to record the attorney-client privilege section of an executive session. Where is all of this coming from? This is the first meeting that any of us hear that you are going to get a new lawyer. Well, the last one, it was like some surprise, but now there's apparently a process that's been underway by at least one candidate that's already in the pipeline. So can any of you who been involved in this, I really think that it's your duty to tell us if you guys have authorized Mr. Gessler, who's not your counsel, to do this for you. How did you do that? He's co-counsel as litigator. Please explain this.
Okay. Can you unmute Rhonda?
Rhonda, you should be able to unmute yourself.
Yeah.
Yeah, I just wanted to, just speak in order and not interrupt, so to raise my hand. At that meeting, what was advised is that any changes would have to go through a public process, and that no decisions could be made at that time, and it needs to be discussed. And so that's what my understanding is. The purpose of this meeting is to have that discussion. And what I understand was, as had been read, is that this is not the intention is not to replace general counsel, but to discuss looking at hiring additional counsel to help with the day-to-day meetings while Scott and Joe together work on the trial, while Scott and Joe are in that, involved in this. Now, I'm interested to hear from Joe tonight because we haven't heard from her yet. And I think, she wasn't present at that meeting. And also, my understanding is that if a process like this is agreed upon by the directors, then an RFP would need to be provided. And as noted, all candidates would have an opportunity to submit. So that is, I think there's been some confusion. I've seen a lot of letters by folks and some comments tonight that there's concern about replacing the general counsel, and that's not, based on my understanding of the meeting, and as was read from the public record, that the intention is not to replace public counsel, and the discussion is being undertaken this evening. And I saw that Scott had his hand up earlier, but I guess I'm really interested to hear from Joe, since she was not present at that meeting.
Okay, I am curious too, who, maybe it was in the meeting and I missed something, but how was Scott authorized to interview candidates? That's just really strange, since it was not voted on. I would like to move to recognize Ms. Bronson, if that's acceptable. Okay, we have a question. Okay, would you like to unmute yourself?
Brenda, you're unmuted. Go ahead.
Brenda? Hello? That's a new. Okay, I can't get you. Can you help her?
She's unmuted, Adrian, but maybe she's away. So I suggest we just mute her and leave her hand raised. And if she wants to, we can ask her again later.
Okay, so I would like to, I think that's an excellent idea. Joe, would you like to answer?
Okay, yeah, I had no idea last week. It was not on the agenda, obviously, about a termination of my position. I can tell you, my position is that at this point, the district is facing some very serious litigation. There are 7 lawsuits currently pending. In a collection of 5 of them, the plaintiffs are seeking $140 million. You would think we would be spending our time discussing that issue. But the point is that I believe that the introduction of an additional lawyer at this time would be disruptive. It doesn't matter how they would fit into the spectrum. That would be a disruptive process. I think it would compromise the district's best interests in reaching a good outcome, an optimal outcome of this litigation. We have trial in August. That is not far away. We may end up negotiating a settlement. We don't know what's going to happen right now, but we are going full speed right now. And it's like a high wire situation when you're dealing with $140 million and 7 lawsuits. I think introducing another lawyer at this time would be very disruptive to that process. And so I think that, if the district wants to change out their legal counsel, maybe when this is all put to bed and there aren't loose ends hanging, would be a good time to do that.
Okay, thank you. Shall we move to anybody else? Miss Bronson? Okay. Brenda? Can you unmute yourself?
Am I unmuted?
Yes.
Joe Timmons, I would like to hear your winning argument that we voters are supposed to vote. This is my understanding of it, is that we voters, you wrote it, so I shouldn't be trying to say it, but I would love to hear your winning argument for why we're going to win this lawsuit because of your brilliance. I would love you to state that to me. Thank you.
Oh, well, Brenda, I don't really know which is the winning argument that anyone has referred to here tonight. I know we have multiple arguments. These things have actually all become part of the public record because we have filed briefs in these cases. I know that one of the things that I think is one of the more is a violation is that under the old IGA, the agreement required Green Mountain to own and operate a big part of a sewer system by Big Sky. That was a Big Sky sewer system that was outside of Green Mountain's boundaries, outside their jurisdiction. Certainly, this is a multi-year financial fiscal obligation, and those need to be approved in a very special way. They have to either have a budget appropriation for the full amount of it, which is multi-millions of dollars going into the future, or there has to be a vote of the people to accept that. That would be under TABOR, the Taxpayer Bill of Rights. Or under the local government budget law, it would have to be, the budget amount for that would have to be appropriated in advance. Green Mountain doesn't even have the reserves to appropriate to that amount of money. Or the agreement itself needed to be made subject to annual appropriations, which basically allows Green Mountain to every year decide whether it wants to continue on or not. Because no board is allowed to financially strap and bind a future board. Financially. That's just a policy of the state of Colorado. That's the basis for the local government budget law. So a board cannot put a future board into a multi-year fiscal obligation without either appropriating the money at a budget hearing where the public are present, or making the agreement subject to annual appropriations. That's one of the arguments that we've made. We have others, but I do believe that's one of the ones that you might be referring to because that would have required public approval.
Okay, does that satisfy you, Miss Bronson? I can't hear you.
I'm muted.
Yeah, okay.
Okay, the host had to unmute me. At any rate, I think it did. Is that that what I heard is that that's the winning argument, and that no one else thought of it. You thought of it, and it's brilliant, and that's why we should retain you. And thank you very much for doing that for us. And right now is the right time to negotiate. Now we can get what we want because we're in a sweet spot, and we can negotiate with the developers and get what we want. And I would like to cede the rest of my time to Devin Neal if she wants to take it.
Director Hannigan, may I address the board for a moment, please?
Please do.
I just explained why I had spoken with with an attorney, and to characterize that as an interview, I think is wholly inappropriate by either members of the public or anyone else. And in fact, the reason I spoke with an attorney is because they had sent an engagement letter to the board or to the district, and I specifically sought to forestall any accusations or issues regarding an inappropriate process, and that's why I reached out to the attorney. And I would also note that the board did talk about a Title 32 counsel, getting that in addition to Ms. Timmons, and I think Ms. Timmons' points are well stated. But because I was the attorney here at the meeting last week, and I'm sorry that I don't have my video on. Since I was the attorney at last week, after the executive session, which was wholly and appropriately legal, it was necessary to provide legal advice, and that's what happened. There was a discussion about placing on the agenda a discussion item with respect to the structure of general counsel. And that's why I believe Mr. Krakowski put that on the agenda. And for what it's worth, it may be valuable to allow the board members to have that discussion rather than constantly responding to public comment, which is very valuable. But it nonetheless seems somewhat astray in explaining to the public the legal arguments of underlying litigation, which seems to be somewhat a departure from an effort to go through the agenda. So for what that's worth, it was discussed last week, and that's why it was placed on the agenda. And there was not a decision made in executive session. I think Director Peters was absolutely correct in her characterization.
Okay, can I ask a question, Mr. Gessler? When was the earliest that you spoke with Mr. Shohit? And when did he send his letter? Do you have that information handy or no?
I don't remember when he sent his letter. I believe I spoke with him on Friday, but I'm not absolutely sure about that. It was last week.
Friday.
And after I saw his letter, I immediately I reached out to him.
Mm-hmm. Mr. Shohit's letter. Okay. Thank you very much. Mr. Arlen? Yes? Christopher?
I didn't need to be unfair.
Yeah, there you go.
I just have a quick question for the board, and that is, what is the end game here? What does winning look like? That's it.
Okay, thank you very much. Okay. So let's see. So this was, so I wanted to ask about, I guess I think I already asked that question. So you chose to, Mr. Gessler, you chose to reach out to Mr. Shohut, out to him, and I was just wondering, oh, yeah. So how did you choose to reach out to him? He just sent the letter and then you responded, is that it?
Ms. Hannigan, what he did is he had sent an engagement letter. He had sent an engagement letter, which he had signed, and that indicated an anticipation that he was on the verge of getting an engagement with the district.
Oh, really?
I don't know why that happened, nor do I know why he sent it. But what I did do is immediately call him to tell him that it was uncertain as to what direction the board was going to take, and that it was uncertain as to what the process would be, and that was going to be discussed and voted on, my understanding, at the next meeting based upon the conversations. So if there is a view that somehow that was improper, I would strongly contend that's not the case, because if anything, what I did was first, as a matter of professional courtesy, to speak to another attorney to explain to him that there is not an engagement, that there's not an engagement pending, and that the board has decisions to make. And that seemed to be absolutely appropriate, regardless of what others may think right now.
So you think, so what you're saying is it was a totally unsolicited letter, that's it, okay.
I'm saying I don't know. What I am saying is that I saw the letter and reached out to him.
Okay, thank you, okay, Miss Neal? Are you unmuted?
I think, am I unmuted? I think I
Yes,
am.
you
All
are.
right, so the answer is very simple, guys. Look, pull the damn Band-Aid off. John Henderson is orchestrating all of this. He's behind it. The entire reason that Scott received this totally unsolicited letter is because John Henderson, one, doesn't want to acknowledge that Joe wrote the winning argument. Two, he doesn't want development. And the bottom line is, the way you stop development in this valley, money that would come to Green Mountain, you replace general counsel, all right? You replace general counsel, because general counsel, not litigation counsel, would be the person who has the conversations, if any were to actually occur, with Big Sky. Joe wrote the argument that Big Sky is basically going to lose, but now there's an upper hand to negotiate the contract. John does not want any building over there, so he's getting new counsel. This is classic, underhanded, basically coup within Green Mountain. The question is whether the board members have the guts to stand up. We know that he's got 3 lackeys on the board. Henderson is a narcissist. Everyone knows it. If you look at his behavior across years, which I have now witnessed, it's narcissistic. It is what it is. This isn't like a bad word. It's not nastiness. You know, people have depression. It's the same thing. He's a narcissist. If you look at his behavior through that lens, everything becomes clear. Thank you.
Okay, thank you very much. Would anyone else like to respond? So shall we, so we were going to discuss,
I'd go ahead and respond. Again, I think that there's a misunderstanding. I don't think that the discussion is to replace general counsel. I think, as I understand it, the discussion was to take place tonight to deliberate on having a Title 32 lawyer to facilitate in the meetings so that Joe and Scott can focus exclusively on the trial. So my concern is that what I understood and had been repeated from the recording of the meeting as well was that this discussion would occur. So I'm interested in having that discussion and understanding the pros and the cons. And I've heard from Joe, I have some additional questions for her. I've heard some from Scott. And, you know, I think the result of this discussion is either to look into the possibility or take a vote on an RFP process, or to take a vote or not take a vote or not make a motion, to deliberate and to decide not to add a Title 32 lawyer, but that would be the purpose of such an addition would be to help run the meetings, you know, the basic mundane day-to-day things, so that Joe and Scott can focus on the settlement discussions and they can focus on the trial and responding to all of the needs that arise out of that process.
And I agree with Director Peters. So that's what we were hoping to have a discussion tonight. Do we need to put in an RFP for assistance with the day-to-day operations in the district, and then free up Joe and Scott to pursue? And to Mr. Arlen's comment, what does winning look like? This is part of what winning looks like, is when you have attorneys that are outgunned, you need to be able to focus on the deadlines that are rapidly approaching. We have a couple of deadlines, and we're once again in a meeting that we should be trying to discuss how we're going to get to there, and we're doing this. So I think you did a great job on that, Director Peters, of voicing that, and that's what basically was coming out of the last meeting.
Okay, I'd like to acknowledge Director Plotkin. You're unmuted, I hope. Are you?
Mr. Gessler, what is the date of an email that I had sent asking for the board, to consider a couple of possible settlement positions?
I'm sorry, I don't have that at my fingertips.
I mean, I think it was copied to you in Ms. Timmons' post.
Yeah,
And other board members should be aware of that email by now as well.
I'm sorry, I just don't recall it right now.
I'm not aware of any email. I'm not.
March
Wasn't it
1st.
February? I was thinking
March
February
1st.
or something. Okay, February. Okay, I was thinking end of February. Okay.
So here we are almost 2 months later. What's the problem, I guess? We were told, the board has been told several times about how, everybody's busy with litigation and everything, and why is this still a thing?
I don't understand the question.
It doesn't really matter.
All right. Okay. So,
So I guess I want to keep us focused on discussion about, does it make sense to put out an RFP and to start the process to get an additional Title 32 lawyer to help manage the day-to-day, more mundane, routine needs of the district? And we heard from Joe that it's not a good idea to replace general counsel, and I certainly agree with that. And I don't think that that's up for discussion at this point. But in terms of adding somebody, and there have been discussions about John Henderson, and I had asked the question specifically, is there an interest in him providing this? And the answer was no. Folks are interested in somebody who is not necessarily involved within the district at this point, that can provide that day-to-day advice that is outside of the scope of the trial.
And also, Rhonda, just in response, I do have other lawyers in my law firm who can help me as needed, and occasionally they do jump in and help me with research projects and things like that. I mean, so I don't know, the day-to-day problems haven't been a problem, but I guess I'll just go back to my original comment that at this time, right at this juncture, I mean, we've only got a few short months until we face either the trial or resolve, So I think at this time, you're introducing a potential disruptive factor. That's what I would say.
I think that we have, how many different lawyers do you have? Joe, do you have Andy, right?
Right.
And your daughter?
Yeah, my daughter also recently graduated from NYU Law School and Harvard College. She helped me out at no charge. You never saw her bill because she spent dozens and dozens of hours helping me with the document production in the beginning last summer, sorting out all the documents. She did that free of charge, just for the sake of getting the experience because of the lockdown. She works for a Wall Street law firm, and they basically were told go home and work remotely, and they hadn't gotten them up and running yet. So she offered to work for me. Also, I have 2 other litigators who work in my office as well. So I'm just saying there is potential there for assistance, but I think the biggest thing is the focus on what we've got going on right now, which is we've had a lot of distractions over the last few months, and I would like to avoid that over the next 3 to 4 months.
So the thing is that, so the cost of a new Mr. Showhead, I guess, would he be like $250 or $500 an hour? That is going to greatly increase our budget. It's something to think about. How much is it going to be 20 hours during Cora's? I think one of the big things is is maybe a law clerk who could do the Cora requests and things like that. It's just a thought that I had. Is that, is that like 10, I know we've been getting tons of Coras lately, and I think that they have sort of overwhelmed maybe Mr. Kropkowski and the staff. Maybe he can comment on that too. So that's just a thought. Mr. Kropkowski, do you have anything to say about the sheer volume of the Cora requests and things like that?
I think you accurately summarize it, Adrian, that there's been a lot, and it is hard to keep track of. I think, going back to public comment earlier, Mr. Mueller, Sam and Jesse in our email system tracked down his request. On that day, April 20th, we received 3 other Cora requests.
Wow, okay.
And so I offer my deep apologies to Mr. Mueller, and we will get that out to him in 48 hours or less.
Mm-hmm.
And it's just, it's as you state, it's just a lot.
It's a Zoom.
So we're trying, we're trying our best. I am the records custodian, and we want to make sure. Some are simple. They just want financial records, and financial records are financial records. Others, I know, need a legal eye to take a view, and in that regard, so far, we forwarded it to Joe, and Joe and her team would work on them, and we would get stuff out to the folks. So that's what we'll do regarding Mr. Mueller. April 20th for some reason was a big day. So
if there's something simple, and if you could show me how to do it, I'd help. I would.
Yeah, I appreciate that. We have this system set up in software we purchased called Elements to keep track. It generates a letter where the individual agrees to the information, especially if there's a cause, because the resolution that the district passed on Cora some years ago is that the first hour of staff work is not charged, and then every additional hour is charged at $30 an hour. Okay. So, like, for instance, we just processed one that came in after April 20th regarding audio recordings, and it took Mr. McKay about 3 to 4 hours to assemble that. Oh, wow. So we had to charge. We got the money today, so we're gonna get the items out here in the next 72 hours, so by Friday. So I will get on Mr. Mueller's request, and we'll get that to him as soon as possible.
So I wanted to ask that perhaps the Cora stuff could be done by, say, one of your law clerks, right, Joe?
Yeah.
Okay, I just thought I'd ask.
Yeah, if Joe wants to give me a name of someone if I need the legal review, like I said, if someone wants to know how much was charged for this on a certain date, especially if it's in the past and the money's been paid, I generally just send that information out because it's of no, from my perspective, it's of no legal standing in terms of, so the desire, I mean, I don't see a need to bother legal staff with giving me a thought on that. Now, if someone wants emails or someone wants correspondence, then I'm definitely going to go to legal and ask for some help.
Okay, all right, okay. So further questions are from Devin Neal. You're unmuted.
I want to say something as a female lawyer that I find incredibly offensive, and I hope that it is taken seriously. This concept that we need to hire a new lawyer because Joe needs to focus on litigation is misogynistic. No one even talked to Joe. How, as a board, do you believe that you're going to get the trust of your lawyer to you? Okay, think about it. Think about what you have just said to her. We don't trust you to do our work. It's totally misogynistic. I don't think anyone, all the women on this call, if your boss came to you and said, "Oh, sweetheart, I don't think you have the time to do this work," when you are busting your ass doing the work, do you think that might be offensive? Where are your emotions? Where is your common sense? It is disgusting that you are now turning face because, look, y'all can say anything you want. John Henderson was behind this. I understand there's a desire to kind of sweep under the rug what happened last week, but I find it personally offensive that anyone would suggest, without having a conversation with Joe before bringing it up in public, that she doesn't have either the qualifications, the manpower. It's unbelievable. The people who spoke initially at this meeting talking about how basically inept this board is, I'm witnessing it. This is my first call and I'm witnessing the craziness of this board. Look, if you guys vote for a new general counsel, there will be a recall. This is just unbelievable.
Okay.
So I'm gonna on to that. Yeah, I appreciate that this is the first meeting attended. There's a little bit of history, and there have been some concerns that board members have had requests that have pulled Joe in multiple directions. There have been some discussion. So I don't think that there's ever been a question of competence. I think there's been a question of some of the requests that have been made have been impactful in that sense. And there have been some previous discussions on budget. And Joe made it clear that a lot of her budget is not related just to the trial. It's related to these other directions that she's getting pulled in. I really appreciated that Joe had mentioned that there are some additional folks within her firm. I would be interested to look at everybody and to see what is their Title 32 background, what is it that they could do in, within the firm, as well as other folks that would be outside that are interested. What is the cost, maybe junior partners within her firm or outside. I am interested in getting some more information. Again, do not want to impact the case or settlement, but dealing with some of these more mundane issues that have come up and have certainly taken a lot of Joe's time. And I know myself and other board members have expressed some concerns that about these.
All right. I would like to move on to Kathleen. Can you I'm gonna try and unmute you.
Yes.
Yes, thank you, my dear.
Hi. Thank you, Rhonda, for saying that, because I listened to Devin and my mouth dropped. I've listened to these meetings about 2 months now. I've never, ever heard anyone say those things about Joel. My understanding as a member of the public has been, I've noticed frustration on part of the board members that they aren't getting information, I believe, that they need from their attorney. That's all I've heard. I've not heard misogynist comments. As a woman who owned her own business, Devin, I'm actually offended by what you're saying, because I don't think many women who have worked their way through their career, they don't feel that way. They feel they've been given equal opportunity. So I am taking some offense against Devin's comments, because I think that's kind of a cop-out, to be perfectly honest. Rhonda, I appreciate what you said, because I think listening to this, I'll repeat, this is what I have heard exactly. The board is frustrated that they can't get the information they need from their attorney. I don't think it was any kind of a personal affront against her. Thank you. That's all I have to say.
Okay, Brenda?
I'm just responding to Kathleen's thing. I did interpret it as an attack against Joe, that they tried to fire her. That they tried to fire Joe at the last meeting in an unprecedented motion onto the board based on a nothing comment. And I want to know what these three nothing, what does this 5A and B mean? I've asked many, many times to Greg Kropkowski to give me a board meeting packet that explains what 5A and B means, and nobody will publish a board packet. And to dismiss Devin's comments, she's made 16 emails that are intimidating everybody on this meeting tonight, and I'm happy that you're intimidating everybody on this meeting tonight, because you need to be intimidated. But on the other hand, what does 5A and B? What do your agenda meeting minutes mean? Who put them on there? And I know you did, Greg, but who told you to put them on there? And I would like to know that.
So Brenda, the 5A and B is the agenda item. So you see Directors Matters is 5, and A is discussion adoption of framework under which district will receive legal guidance and representation. It's meant to be
that? What is that?
It's just meant to be discussion by the board based on what Scott Gessler said earlier, based on what happened last week. That the board
I know what happened last week. That led to this week. So what was that to me? Because I've been asking you in emails for this week, and you won't publish the board packet. You said it was removed, and then you told me it was put back on. But I don't ever know what was in the board packet.
If I'm given items to put in a board packet, then I will happily put it out. If I'm not given items, then I don't.
Who gave you the items that you were given to put in the board packet, Greg?
Well, Brenda, all they said was essentially this
Who
sentence.
is they?
All right, can we not?
Please stop harassing the
wait a minute,
manager.
Wait.
I can speak to one item. One item was mine, and I can speak to the to B, I believe. Let me just pull it up and confirm. So item B.
That's CDN Smith that you said you wanted on.
That was my item, and I am, I'm very focused.
But I've asked for the report, Rhonda. I've asked for the board packet. It won't be published.
Just a minute.
It wasn't published.
Just a minute. Let's
Point of order,
not
please.
yell at
Can we
each
get
other.
this back to
Yeah,
the
please.
discussion?
Please, just a moment. I'm trying. Just a minute. I'm trying. Okay? So, let's not interrupt each other. See, I am trying. All right? I would like to ask, okay, Miss Bronson, what you're saying is that all you received, is this correct? That you received this agenda and nothing else, right?
Well, I received an email from Greg Kropkowski that I didn't solicit, that said, heads up, we tried to publish a board packet, but it was removed by the board. And I have never seen anything that supports 5A and B, and I asked specifically for it a number of times.
I am curious what exactly was removed by the board at this point.
I don't know.
I think I have the answer.
Because he
just a minute.
It was removed. Okay, there. So he interrupted me. That's okay.
Yeah. I'm sorry.
I'm used to it because I interrupt people, so I get it.
Okay. All right, let's have a moment of levity. Okay, so Mr. Krupkowski, so was there a board packet? Because I never saw it.
Okay, so
I didn't see it.
Let if I could just go for 3 minutes uninterrupted, I give a body part. I hear a lot of times that even the agenda is not findable by folks, and I know we go out of our way to make sure we meet statutory guidelines to publish the agenda 72 hours in advance. Now, a board packet is a different matter. It is additional information if the information is available and given to me and offered up by either other directors or legal counsel if it's legal in nature, and I will happily assemble that and put it out as quickly as possible. So what I had said to Ms. Bronson was that the meeting prior, where there was the flow charts discussed by Mr. Gessler, what Scott had done is he had offered drafts on Friday, and my goal to get information to the public is so strong that I went ahead and I thought it was good enough to put the word draft across it and get it out to everybody. This is the April 20th meeting, not tonight. So on Sunday, Scott got a hold of me and said, hey, that really wasn't for public dissemination because it was draft. Greg, you moved too fast. So please take that down. So it did come down. And then as soon as Scott got me documents he felt were good to go, which was Monday morning, we put the document back up, and I notified you through email, and that was April 19th, right prior to the April 20th meeting. That's what I meant. So then, talking about this meeting, when I got an agenda, so as not to have you get confused, where the agenda might be, I just sent it to you as an email. I sent it to 3 or 4 other people almost as a courtesy to say, please don't go looking for it. Here it is. And what I mentioned is, as of this moment in time, I have not been offered documents to put in to support any of these items. So it's just sentences to be talked about, and the meeting is largely going to be discussion. So my goal was, one, to help the public out with as much information as I had. That was my goal. Me talking about a board packet coming down was related to the April 20th meeting. If I wasn't clear on that, I've got to get better at being clear, and I apologize.
Director Hannigan, may I make a comment, please?
Yes, please. Go ahead.
For what it's worth, I think it's really, really, really important that the board have a discussion among itself regarding these litigation and settlement options. I'm deeply concerned that we don't have much time before we have to commit ourselves. And if we're going to do that, we have to commit ourselves with board direction. And I think that requires some discussion. I'm hopeful that perhaps the board itself can have a discussion on this agenda item, and I'm respectful of public comment, but it seems as though the board members are not getting a chance to have this discussion at all. And I'm hopeful that they can have this discussion and at least, now I'm taking no position on this agenda item, but at least work their way through this agenda item so that we can get to the litigation and settlement discussion, because without that, we've got some problems here on the litigation side because we need some direction. So I'm hopeful that perhaps the public may refrain itself from some of these constant input and frankly insulting comments. Some of them are insulting, not all of them, of course. Some of them are very respectful. But it seems as though there's no motion getting to the point where I feel is absolutely critical. We have to work our way through this agenda, because if we don't, I am deeply concerned about having a direction from my client here. So may I please just urge that? This meeting's gone on an hour and 40 minutes, and it's almost all been public input with very little discussion among board members. And I'm hopeful the board members can have these discussions so we can move to these items that is necessary for Joe and I to have the direction to be able to resolve this litigation or settlement one way or the other.
Okay, with directors' matters, I don't see anything regarding settlement. All it seems like it's representation and guidance pertaining to ongoing litigation. I don't see the word settlement in here.
That's the ongoing litigation. One of the options is settlement as an option, and
because I didn't see it here.
It doesn't have to contain the word to actually be on the agenda, because that was part and parcel of the entire presentation that I made last week. So if your view is that the board is not prepared, or it's outside of an agenda to be able to countenance what our litigation options are, which is always settlement as one of them, I'm fine. I will depart from this meeting because there's no need for me to be here, and perhaps in the future, one of these days, we'll be able to get the guidance. But I think it's imperative, and I do think it was properly noticed, that that the board has a discussion on what to do with this litigation, whether we are going to go full bore and litigate this, or whether we're going to seek a settlement. That is something that's important, that I think Ms. Timmons and I have been begging for board guidance for about 2 months now. And I don't see us making any progress towards it tonight. And I'm hopeful, I'm praying that we can get some guidance tonight, and there can be some discussion among board members, perhaps without constant back and forth with members of the public that are pulling the board off task. So I'm sorry to express my frustration, but God, we need this guidance, please.
All right. So if I could just.
If I may speak.
I'm sorry. Go ahead.
As I mentioned before, my email about the settlement potential options went out on March 1st. May I just remind everybody? And again, the task tonight, and to, kind of second what Director Peters had said earlier, was to discuss having counsel for Title 32 help. So if we may please get back to that, if we may please end the public comment, this is kind of, I think, what Director Morgan was trying to do earlier, is this is how pretty much every other meeting has gone on. There is, all due respect to the public comment and input, but this is a board meeting where the board members, I hope and pray, as Mr. Gessler just said, that we can sometimes have a discussion amongst the board members without being interrupted. Thank you.
Okay, Ms. Timmons, you had something to say?
No, I was going to say in response to what Scott said, one of the items we do have on the agenda tonight is discussion of the CDM Smith report. And that is something that we have been trying to work through, and Rhonda put that on the agenda. So that is something we absolutely can talk about tonight. It is on the agenda, and I know it's something that Rhonda has been wanting to talk about. We do have an executive session if required, but I'm not sure, Scott, what type of discussion you're talking about. If you're needing a discussion in the open meeting, we don't have that on the agenda tonight. But we can certainly talk about this engineering issue, because I'd like to hear some about that.
Okay. Rhonda, are you able to talk about that?
Yeah, we might want to wrap up with the A item and then move into the B item. So okay. I think we should maybe finish up on the A. And okay. I guess I would just, maybe we could think in the future in terms of the public comment, the way City Council does. They have a specific section, and then, kind of a call, at a certain time where you can sign up to speak on various topics, or each person gets one opportunity to speak. That might be something to think about for ongoing meetings, and just to consider. I see that Director Plotkin has his hand up for comment. I have more, but if you want to comment on something.
You just described verbatim what I was trying to put into the last edit of the bylaws that I recall of.
So that's fine. You know, I think that if we had a Title 32 person, they could work on bylaws, they could work on some of these other issues. It's fine with me. It could be somebody from Joe's firm, it could be somebody from the outside. I thought the idea of discussing it tonight and putting forth an RFP to investigating and get some input on that was a good idea. What I'm wondering, and this is a question for legal counsel, either Joe or Scott, if we put an RFP out, are we obligated to hire somebody, through that process? Or if we go through and then we decide, okay, we don't like any of the candidates, or okay, we've decided that it's not necessary, or we've decided we want to use somebody through Joe's firm. I mean, what are our options legally to be able to do that?
Rhonda, I can tell you that if you put out an RFP, that doesn't mean that you have to hire somebody.
Okay.
That's one thing in answer to that question.
That's helpful. Thank you. So we don't have to hire anybody. We're not obligated. We can just take a look at what is available, and even what about if we go through an interview? If we have certain questions that we want to ask everybody related to their background, their experience with Title 32, their experience in some of the areas that have come up, is that if we interview them again, does that put us far down that we have to make a commitment, or can we decide, okay, we've changed our minds, we're not moving forward with that?
Right. No, you are not obligated.
Okay.
There's a certain process that you do have to follow, to go through those steps you just described.
Yes.
But there's no obligation.
Okay, so I would suggest that we follow that process and we go through the steps as Joe has outlined, and we make a decision if that's what we want to do this evening, and we have a discussion and move forward, and then finish up with this agenda item and then move on to the next one. And I will lower my hand.
Okay. Mr. Plotkin?
The agenda items on September 13th, 2018, prior to the establishment of the hiring process were: number 5, establishing an interview process for the Big Sky RFP; number 6, scheduling and calling a special meeting of the board to select and hire an applicant for the Big Sky RFP. Judging by the fact that I have no other documents that travel with that agenda, I presume the board just established an RFP process, had the district manager post a thing, and moved on, and then the rest is history. So can we just please move on to, with the process or establishment thereof?
Okay, go ahead. All right.
So do we need to make a motion to have an RFP for day-to-day issues addressing the water board, not litigated, not a litigation or anything with the IGA or anything to do with the lawsuits? It's just for the day-to-day operations of the district.
You just froze.
Made a motion.
Can you repeat that, please?
You just froze for a second.
So just to clarify, is that then for the general counsel? Is that what you're doing?
No.
Justine?
No.
Oh, okay. I'm sorry, Jeff. I didn't hear what you said. I think.
So to be very clear, I was trying to say for the day-to-day district operation, the mundane stuff, that's been the word used tonight. Nothing to do with the litigation, anything to do with the lawsuits. That still falls under you, Joe, and that's what the discussion, I think, with all the consternation around the 5A with delineating that probably. I don't know which should come first on that. I didn't put this in here, and I know that Greg's taking a lot of heat for all this. This is what the board just talked about last week, Joe. And so we're trying to come up, and the motion is to
How about
look
a Title 32 specialist, so it's not confused with general counsel? Because that's my concern, is that folks have had a lot of confusion, and that's certainly not up for discussion, is, hire a Title 32 specialist for day-to-day, RFP for a Title 32 specialist. And I think if we put together some questions potentially for an interview that would relate specifically to Title 32. Jeff, just a suggestion.
Yeah,
I would caution the word specialist because we got burned by that once. I would make sure that it's Title 32 legal counsel.
Okay, perfect.
So what do you think about the, Director Baker, what do you think about the RFP process tonight? Do you have any thoughts about that?
We can't, well, obviously we can't do that.
We're discussing it now,
We're discussing it, but you have to put it out there. And if for the discussion, I make the motion and we discuss if we want to put out the RFP.
Oh, you want to put out, okay, gotcha,
Yeah.
So
okay.
I'm trying to allow the board, I'm
To
trying to
discuss
get
it.
things moving forward so we can get on to Director Peters' 5B about the discussion of the CDM Smith report. So I'm trying to clear the deck here.
Yeah.
Making a motion for a Title 32. Alex,
Legal counsel, RFP.
okay, motion for a legal counsel, Title 32, an RFP to be posted. So now we would, okay,
Would you be interested in time bound on that or anything like that? Can you be a little more, I don't know, specific, I guess, Jeff?
it's basically to when I've sat here and I do know what Joe and Scott are under. I know they're under these extreme pressures. Now we're under these extreme deadlines. I think if the point of load shedding a little bit to where the district basically it is operating and it needs the day-to-day type like these Cora requests that Mr. Mueller had brought up. There are things that come up that require the attention of a day-to-day type Title 32 attorney that knows how to manage this in a very timely manner. It is mundane for them, and it is getting back to Mr. Orland's thing. What does winning look like? This is trying to win, trying to get to some point, and quicker would be better. Thank you.
Okay.
So can I ask because I am confused too, and I thought I have a different definition in my head of general counsel, so I thought that is absolutely what we're doing, and just what you're saying is general counsel. And I thought that was what I had heard Mr. Gessler, that was his term, because I was using something different beforehand. So maybe you could give me your definition if you are still there, Mr. Gessler. Because the other thing I'm worried about is the overlapping of duties, to have that clear delineation between the litigation and what is general. I thought general counsel was just the day-to-day mundane, come to the meetings, and do all of the stuff that you're describing. So we're using the same words but with different definitions.
So
If I could respond, can I respond, Scott? Since I am currently the general counsel and also the lead counsel on the litigation, and the general counsel, the litigation attorney would report to the general counsel. So my original comment was that I think at this point in time, it could be very disruptive to introduce a third lawyer, or more than that, because I do have my firm work with me on this. But I think that would be disruptive at this time with this litigation going on. That's just my view about it. I think if you want to hire somebody to do some of the Cora things, that kind of thing, but to have something where suddenly there's another person with authority over the litigation, I think that's potentially disruptive. And I don't think that would be a good idea until we get through this.
How can we make it clear that this individual would not have authority over the litigation? What's the, how would you delineate?
Well, if you're gonna hire a new general counsel, their authority is over all of your work, everything. Okay.
Yeah, and I don't support that. I would not support that. And I did not believe that that was what we were discussing tonight.
Okay, so right now the board is paying for Joe. It is paying for Scott Gessler, Andy Estuno, and possibly Mr. Shohit. You know, I think that, I don't think this will play well financially with, with our constituents. And that's all I have to say on that. If we could have somebody, step in temporarily with Joe's office, like a law clerk who could handle all the chorus, would that be helpful?
I would like to get through one of these board meetings one of these days where we actually have some sort of a flow and we have a Title 32 support and explanation of some of these matters. So I don't think a law clerk would quite cut it. The intent, I think, here is to have a Title 32 person, again, handling the day-to-day operations, board meetings, core requests, and things of that nature. So I've expressed some of my sentiments. I do feel like they're not being listened to. So at this point, that's all I got.
Well, I don't know.
Sorry,
Okay.
Director Plotkin, can I ask you the question? So what I'm hearing is that it's the difference between a general counsel and the Title 32 is Joe saying that that it's a chain of command. And maybe you can say that better, restate that, Joe. But what I'm hearing is that you think there's a possibility, not that you support this, Joe, but there could be a possibility, unsupported, that we could hire somebody else to do the Title 32 stuff, but they would still have to report to you. And the other thing would be to, and is that what you were envisioning, Director Plotkin, would still be having that chain?
No, I think this would have to be a person who's just independent Title 32 support because, again, I'm not going to go into it here because, I'm going to get accused of things that are not true again, and I don't feel like discussing this anymore. I want Title 32 expert just helping us conduct the daily district business, and I've stated any number of issues, and again, it's, here it's portrayed tonight as if, none of that has taken place. So I don't feel the need to discuss this any further. I would like Title 32 expert to support the board with Title 32 issues in the day-to-day operations of the district. Thank you.
Okay,
Rhonda?
Yeah, I just had a question for Director Plotkin, and because I know that I've seen emails that have come into the board, and I just want to make sure that my understanding is correct. And people have asked about this, and to the best of my knowledge, there's no interest in bringing John Henderson in. Can you confirm that that is true?
Jesus Christ, can we just stop talking about John Henderson for once, please?
It comes up. I just would
seriously, this goes to my point of no matter what I say, it will be used against me. I am done discussing this.
And I should point out, I'm not sure what that means by Title 32 because our litigation, a lot of it is about Title 32 as well. So that is one of the big issues in our litigation. So I'm not sure if, what this means, if this is a way to somehow, I just don't want any disruption for the next few months.
I've been asking for settlement terms to be presented since at least March 1st. Why are we still talking about disruptions and litigations and anything else?
Can you let's make it a more positive tone, please? All right. I know this is board meetings tend to be contentious.
But order, did we have a motion on the floor? Did it have a second? I'm just trying to.
No second, no nothing.
I'll second.
Okay, so discussion then.
Oh, what was there a motion? I'm sorry.
There were two motions. I made two separate motions that I tried to correct, and then there was nothing. We've been discussing it for the last 10 to 15 minutes.
Okay,
And,
procedure is to
and
make.
may I point out, since, you know,
Can we restate what the motion is, or
Please. What was it that
Yeah.
you said, Jeff?
Oh, I think we're trying to get the motion. You're trying to
Yes.
get the language for a motion.
Yes, that's
where
what it
we are.
was.
That's what the discussion has been. Okay.
Yes.
Correct.
Thank you for that clarification.
So I wanted to make a motion to create an RFP for a Title 32 attorney to support the day-to-day operations of the district and of the board. There's the motion.
Could we add without something that doesn't impact the trial? Joe made the point that there are some Title 32 issues in the trial. Is there a way to add something to clarify
Well, that's where the discussion in 5A was supposed to occur, but this meeting has been so fractured that we were trying to delineate the swim lanes on that and have that discussion, but then that never happened, and so.
All right. Okay. So you made a motion. I wrote that down to create an RFP for a Title 32 attorney. That's just it, right?
For the day-to-day operations of support the district and the board.
Mm-hmm.
If
Okay.
I may.
And where I wanted to ask, and is there going to be a chain of command? Who's in charge? So
Adrian,
just ask that. Yes.
honor the motion, please. See if there's a second, and then we can have a discussion, and then we can vote, or one way or the other.
Yeah. Well, I'm just asking. I wanted to clarify something in the motion.
Well, it'll
That's what I
have
asked
a
for.
discussion.
Okay. Well, I wanted to ask about a chain of command. But okay. Okay. Do I have a second?
I'll second.
Okay. So in my discussion, how does the chain of command work in this? Go ahead, Mr. Plotkin.
That counsel, since whoever they would presumably be having an engagement with the board, so they would just respond to the board.
So, but so Ms. Timmons is no longer general counsel. Is that your statement?
I have no answer to that. I presume whatever agreement we still have, that's still out there.
So she is still the general counsel. Okay, so where does this other guy fit in? I'm trying to come up with a structure, in my head.
Sorry, I think it could be a guy or a girl. It could be somebody
Right.
from this firm.
I mean, we've had the misogynist terms thrown around out here tonight. It would be whomever would be selected rather than the guy.
Okay.
And if I may, as a point of order, since so many members of the public were given a turn tonight, I believe there is a member of the public who still has their hand raised.
Okay, Kathy Odenwiller had her hand raised first, so I will unmute Kathy. Okay, go ahead, Kathy.
Yes, hi. Sorry, eating a cookie. I had my hand up before and then I took it down. But I just wanted to respond to the comment that Devin made earlier about, I think that it was misunderstood because it was just mentioned again. And when she talked about misogynistic, I think really the point that she was making was it's just disrespectful to not consult with Joe first before you just decide upon yourself that, oh, she can't handle all this. Let's get in another attorney. Because that was my first response was like, wow, this could be kind of like weird. And now there's going to be another attorney that like she had like no say in the matter. And so that was my point. And that it's really like the matters, she may be, as lawyer, she's probably experiencing that more often and using the term misogynistic because usually with men, they may not jump to that conclusion. And so that was the point. I think it was misunderstood when somebody, takes that out of context. And it was mentioned again, and that's why I wanted to respond to it. So that's all I have to say. Thank you.
Okay, there is someone, I think it's John's iPad. That would be, I'm going to guess that this is Mr. John Henderson. Is that correct? And you would like to comment from Maine, right? Go ahead. You would like to comment from Maine. Is that correct? Mr. Henderson? Yes? Mute, unmute? Yes? Unmute. I'm trying to do this. Okay, go ahead. Yes,
Hi,
Mr.
Adrian.
Hello?
Hi, Adrian.
Good evening.
Good evening. You keep muting me.
I was trying to figure it out and it just wouldn't work. I'm
That's
sorry.
All right. Listen, folks, it's late. You've got a lot of work to do, and Mr. Gessler is pleading with you to move forward. So I congratulate you on your efforts to do that. Really short, to be totally clear to everyone, in response to Rhonda's question, if anyone were to ask me to participate as Title 32 counsel, as you're defining it and requesting it, I would respectfully decline. I have been available to help out and answer questions from the very beginning when Adrian contacted me in August. I'm still available, but I am not in a position, and really it would not be appropriate for me to be your counsel for the Title 32 issues. So please put that to rest. Thank you all very much. Great to see you all. Please, Godspeed forward.
Okay, thank you so much. Okay, so what we had is that we have this motion, and there was a second to create an RFP Title 32 attorney for the day-to-day operations. And so I would like to ask, yes, Mr. Plotkin, please contribute.
So if I may suggest, I don't think there is actually, I don't know, Jeff, what your intent maybe was specifically. I don't think there is a need to create anything. We can just pull the RFP that was used the last time, and maybe, if I remember loosely, since it was for the Big Sky, what have you, there was a litigation line in there somewhere, so that could be taken out, and essentially that's probably what should be posted on the website. Is Jeff, I mean, what are your thoughts? What exactly were you going with it?
Well, I agree with that. I mean, the last thing, I guess, to the public, to the board, to our attorneys, the last thing we want to do is jeopardize anything on this. And I'm seeing this narrative that somehow three of us are trying to undermine that, and I can assure you that is not true. We are wanting to get something moving forward. So I have no intention to want to mess with the litigation, slow it down, impede it, litigation settlement, whatever that is. We just need to get to it. We also probably, and that's the discussion, do we need the additional support at the district level? I believe we do. That's what the discussion is. Do we need it or not? If we don't, vote it down, move on, get on to 5B, and go with the wastewater system capacities.
Okay, are the discussions complete? Anyone else would like to comment? Ms. Morgan, do you have any thoughts?
I do. I'd like to say I don't see how this works with the way of leaving Ms. Timmons' existing contract in place and perhaps hiring somebody else that would report to her rather than to us. I'm not sure that doesn't seem.
Well, that's a valid concern. That's a valid concern. Okay, so perhaps you can elaborate on that. And anything further from the other directors regarding Ms. Morgan's comment?
Well, that's what I wanted to have, is an actual discussion amongst the directors on the
So
court.
go ahead. Thanks.
Yeah, that's it.
That's it? There's nothing further?
Well, I'm hearing what Director Morgan said. I guess I'd like to hear from Director Peters.
If I'll elaborate and say first of all, since this is, I saw this from our last discussion as a clear delineation of duties. So, and I am sure that there is a way to do that. Say, this is a litigation side, this is the day-to-day side. And so I don't see the problem of delineating that. And that otherwise the purpose of hiring somebody else is not accomplished. So I don't see the point. Yeah, I'll just leave it there.
Okay. So
I didn't understand the point. Can you, Director Morgan, can you just boil it down again? I don't quite get your point.
I think if you're going to bring somebody in to be accountable to the board on these issues, that it needs to be accountable directly to the board and not through Ms. Timmons or her law firm. So if we're going to do another RFP, otherwise, you're right, then just hire somebody else out of her law firm and be or, you know, and she could be doing that all along the way. So I'm not sure. I mean, and she, you know, in point of fact, she did, right, bring in Mr. Estuno, and we've been doing that. So that, otherwise, how did we get here in the first place?
So I appreciate that clarification.
think-
And I guess I would say that I do disagree, because I don't know Mr. Estuno's background and his Title 32 expertise, but I do know that in meetings when he was here and Joe was absent, he didn't have answers, and it wasn't something that he could pull off the top of his head. Maybe there's somebody else in her firm who, you know, is very well versed and has those answers off the top of their head. Maybe there's somebody in a firm outside. I'm interested to see what's out there, both within her firm and other firms as well. And so
I totally agree, and that's why it stopped myself. But in point of fact, I do not know that. I mean, there were a lot of lawyers when we looked at, and I wasn't there, so maybe I'm speaking out of turn, but there were a lot of people applying that had more Title 32 experience, and we have gotten ourselves in some trouble on some of these things. So that's why I like that delineation of somebody with experience on just regular board meeting stuff outside of litigation.
I do believe I said earlier that if there was an engagement, it would be with the board.
You said that, but then we had the whole chain of command conversation. So can I offer an amendment? I move to amend the previous motion. That would be a lawyer, the Title 32 lawyer, directly to the board. That would be outside of Ms. Timmons' chain of command.
I would second that.
okay. So that is, I'm going to write this down so I've got this. Let's see. Okay. Here we go. All right. Okay.
So then I believe we have to vote on the amendment before we can go back to.
So basically, if we revise the amendment, so what we can do is do a revision on that. So you've amended the motion.
So,
And
Ms. Hannigan, if I may make a comment.
Yes.
So Director Morgan has proposed a amendment to the motion.
Yes.
I believe it's up to Mr. Baker to either accept that or not.
Yes.
If he accepts it, then it requires a new second.
Yes, that's what I was going to do. I was actually going to ask for a new second.
Well, first Mr. Baker has to accept it.
Okay, all right.
I accept.
All right,
I'll second the amended motion.
okay. So have we concluded the discussion of this? Yes, sir?
I don't know
Mr.
if this would
Plunkett.
take an amendment, but again, I believe Director Baker, you said create. I would suggest that we post, and then we put a period on it, and then we follow that basically process that we used in the previous, in whatever it was, September of 2018. So we post, we have people apply, and then we establish a meeting where we do an interview, and by that time, hopefully the board members can have their questions ready. And I think last time it was 5 questions from the board.
Can I respond to that real quickly? I think you all need to approve of what gets posted, and you need to put that in a board packet. So I think you're gonna have that, put that together. You can't just post something without it being known in advance what you're going to post. It probably won't be exactly the same as the previous one, and in any event, that wasn't in the board packet for tonight.
I don't believe it was in the previous board packets either, as I was stating. I don't recall it in September being in the board packet.
Yeah,
If I may say something, I think Ms. Timmons is probably correct, and I think it would be valuable for the board to actually see a written document with what that exact posting looks like, so you all can make sure that there aren't any misunderstandings and that you agree on it. For what that's worth.
Okay, I am going to repeat, responsive to read this again. This is my understanding. So, Mr. Baker wishes to create an RFP, a Title 32 attorney, for the day-to-day operations of the district outside of Joe Timmons' firm and responsive only to the board. Is that correct?
Yes, ma'am.
Was that stated well enough?
Yeah,
Okay.
that would not,
All right.
Adrian, that they would have nothing
Yes.
to do with the litigation. That's the point, the edit that would have to occur. That nothing to do with the litigation whatsoever.
Okay, well, I think that that's clear there, outside of Joe Timmons' firm and responsive only to the board. You know, I think that's pretty much implied in there. Would you agree, Mr. Gessler? You know, what I read.
Sorry, yeah, that sounds accurate. I don't know, Ms. Timmons, is that your read of it?
I think what we should do is just wait and see what the RFP says, because I agree, it's kind of confusing right now, but I think when you go to put together the RFP, that's where it will be delineated.
Right. I think there's enough guidance to put together the RFP. We can get that together, then the board can review it carefully and fly spec it to make sure, either the entire board or the majority of the board that votes on it is satisfied with it.
Mr. Gessler, could you work with the district manager with a previous RFP and see what needs to be taken out based on what you just heard?
And I'm happy to do that. Obviously, I'll coordinate closely with Ms. Timmons too.
Okay.
Thank you. Sorry, I muted myself.
Oh, that's fine. So, would the board like to move to a vote?
Well, I guess I just wanted to say that I would have liked to have seen individuals from Joe's firm be able to be considered for this position. So, I know that that's now been accepted as part of this vote. Just because they're being looked at doesn't mean that there's any obligation. It's the board's decision. And so, I'm kind of struggling with that, and I'd like to remove that provision.
You'd like me to remove the provision outside of Joe Timmons' law firm? Is that correct?
It's been, that's Jeff's decision to make.
Well, yeah, I think you have to amend it then, Rhonda, I think.
You want me to draw a line outside of Joe Timmons? I'll just draw a single line through that?
Adrian, let Rhonda speak, please.
Okay, go ahead. I'm sorry. Go ahead.
No, I don't know if I heard you, Jeff.
I think you would have to make another amendment. I would have to accept, and then we would continue on. I'm not a lawyer. I'm just guessing. Somebody that's a lawyer, please correct me.
Can I make an amendment?
Correct.
Yeah, that's correct, Jeff. You're
okay.
Thank you.
You're right.
I make the amendment to remove the amendment outside of Joe's law firm.
Okay.
I accept.
Mm-hmm. And the thing is that this gets confusing now with Joe's law firm, if it is part of that. So it would be responsive only to the board, but then they would also be working for Ms. Timmons. So that, might be a conundrum for Ms. Morgan. Would that be correct, Karen?
Yeah, I think those two are mutually exclusive there.
They're kind of.
Yeah.
It's either A or B, right?
So it could be, let me think for a minute, to put a wishy-washy word in there, to have directly to the board and outside of Ms. Timmons' chain of command, unless we accept that bid or something, unless that they already work with her law firm. Does that make sense?
I am totally confused.
I'm confused too. Can we hear
I want, for
I
example,
think we can work with that. I think we can work with that, Ms. Timmons can submit a proposal to compete with the proposal of an outside law firm.
Outside law firm, thank you.
But the qualifier would be Title 32 expertise.
Correct, and Ms. Timmons can present an option on equal, on an equal footing, and you can compare that and say, well, we'd rather stick with this rather than bring in an outside law firm. And we can put something like that together.
Okay.
And then you all can review it.
Okay, can I read this again? One more time. So we are working to create an RFP for a Title 32 attorney for the day-to-day operation of the board, okay?
And the district.
And the district, yeah, thank you. I need help, thank you. Got you. Okay, that is responsive only to the board. And that would not exclude Ms. Timmons from applying. Does that fit with you, Ms. Peters? What I read, is that okay?
I think so.
Okay, so now shall we go backward and to Mr. Baker? Okay, and ask about is this now the amended wording? Is that acceptable to you, sir?
Well, let me ask the attorneys, does this amendment, is the verbiage all in there, attorneys?
Mm-hmm.
Yeah, I think all you need to do, Jeff, is agree to amend your motion to what Adrian just said.
Then I agree to amend.
All right, okay. So I have one little concern, and I toss that out, is that do we have the budget for a fourth attorney? Would that be covered with Ms. Timmons' firm, or is that gonna, I don't know, I'm not a lawyer. How much more is that gonna add in terms of costs? So Mr. Plotkin, you had some thoughts.
Presumably this attorney would be basically, acting in Ms. Timmons' stead, or, coming to the meetings or whatever. So again, Ms. Timmons and Mr. Gessler can concentrate solely on the litigation. So those dollars would have been spent one way or another.
So what you would want is you would want Gessler and Timmons to no longer attend our meetings. Is that correct, or how do we want to do that?
I believe that's what we just discussed.
Okay, no, I'm asking that they would not be here.
That's my understanding.
And then would they interact with us by email or something, or how would we found out about? Yes.
I think when it's around what we're trying to do, Madam President, to get to the litigation.
Yes.
We're having in theory, we're supposed to have extremely focused meetings on this.
Yes.
And we're not. So I believe that, yes, at that point, you would probably have some doubling up during those meetings.
Yes. Okay. Yeah. So it just popped into my head, and it was I think a valid concern. Yes, Mr. Plotkin.
Well, again, as we just talked about, then the Title 32 person would presumably not be in the executive session, and either Ms. Timmons or Mr. Gessler would be, or both of them, however they deem necessary for that executive session.
Okay.
I agree with that. That individual would not be involved in the executive sessions.
Okay. All right. I was just thinking about how that would work. Okay. Yeah, thank you.
And I think that Andy was participating in the meetings, but he's not now, and Scott has sort of filled in that role. That's my understanding, and I guess I could hear more about that from Joe. And so we would still be in a position of potentially three legal counsel.
Okay. Would we like to move on to a vote? Is everybody?
Well, we also could look at sunsetting this at some point if we settle or go to litigation. There could be a sunset on this too.
Okay. All right.
I'm thinking because they work, everyone works at the will of the board. We can just discuss that. I don't think we need to necessarily have that language. We could probably let people know that up front, but I don't think we have to have language for that.
Mm-hmm. Okay, so I'm going to ask the question again. Are we ready to vote?
I will resecond the motion, I believe, for the intent of maintaining the order or whatever process. due
Okay,
process.
I'll read it. So create an RFP Title 32 attorney for day-to-day operations of the board and the district that is responsive only to the board. So everybody's satisfied with that language? And we're ready to vote on it, right?
Yes, ma'am.
Okay.
I guess I just hear if there's any comments from either of the attorneys on the language.
Okay.
Well, yeah, I think we already talked about if they're responsive only to the board, then, yeah, I'm not really sure. I guess I'm not sure how this is working with, you know, the litigation going forward to make sure. I don't want there to be any disruptions, and I know you guys are trying to set it up like that. And so, you know, that's fine. Just leave it how it is.
Well, Joe, so what do you think would I guess I'm just asking the question. I don't know this stuff, but what would cause the disruption?
Yeah.
What would be
I mean,
the
if
problem?
there is a disagreement, if I run into a disagreement on a legal issue with somebody who says, look, I work for the board and I disagree with what you're doing, and this is not the way we should do this, and I've had this happen to me already, and it's very disruptive, and it's not productive, and it's expensive, and actually we just can't afford for that to happen again. So I just want to make sure there's not the possibility of that happening. I mean, if you think this could wait for a little bit, you know, and maybe it will take that long. I mean, I don't know how long or how quickly this might happen, but I don't want to have it be that there's going to be some disagreements.
Mm-hmm.
I mean, you know, we've got a lot of moving parts right now. We have a lot of lawyers, we have a manager, we have things that are a lot of things going on, and we have this massive amount of litigation. I really appreciate trying to streamline things. I think that's a good idea, but I don't want to have anything. I get worried when you're saying only responsive to the board, and now I don't know how this is going to work. And you know, this could be a recipe for a disruption, is what I see.
So what if that part was removed?
Well,
I would object to that.
yeah, so I think that's what's happened here is tonight is it looks like, you know, there's a desire to get somebody who only responds to the board, and yet, you know, how does that work when we have got some pretty significant litigation and now we're adding another attorney, and, you know, I'm not sure how that's going to work. I mean, I'm just putting in my 2 cents that I understand that you want additional assistance, but putting these restrictions on that, you know, I understand, I guess you want them out of my chain of command, but then, you know, we just have a lot going on with this litigation, and that's what I'm trying to avoid, any disruption.
So let me ask, if it was within your chain of command, I mean, whether it was an outside firm or within your firm, is that, I mean, especially in relation to the litigation, I'm just trying to find a way that could make
Director Peters, we just said they wouldn't be involved with the litigation. And point of order, it's now 8:30. Can we please move to item 5B? Is it possible to do tonight?
I'd like to
sometime
do
tonight?
that. I'd like to do that. Okay.
The motion is on the table. If Director Baker wants to move the question, or if the motion still stands.
The motion still stands. Do you want to proceed, Mr. Baker?
Proceed so we can get through this.
Okay.
Either
So
vote
I think that this has been discussed fully, I think. Ms. Peters, and you have nothing else to add, is that correct?
Can you read it again, please, Adrian?
I'll read it to you. Yes, for the nth time, create an RFP for a Title 32 attorney for day-to-day operations of the board and the district, correct? which is responsive only to the board. So
Okay,
that doesn't,
I would like to make an amendment to remove the word only.
okay, I'm getting confused now. Responsive to the board. Okay, why is that?
Because Joe had said she does not want to be in a situation where there could be a conflict in relation to the trial.
Okay, that,
So,
I think that's reasonable, but.
Director Peters, what this exhibits to me is, again, I've stated my concerns to you as well, that those concerns were not being listened to. So that's my contribution to the discussion in closing. And I would like for the vote to hold place.
I appreciate that, Alex, and I think that we will be able to, in some of the questions that we put together, hopefully we'll have the RFP and then some questions that are put out, and hopefully be able to address that.
Some of my emails and issues concerns from months and months prior are still to be addressed, so I will not hold my breath, but I appreciate the sentiment.
Okay, so the decision is not to amend that? Is that correct?
I asked for the amendment. I don't know if it's up to Jeff.
Mr. Baker, do you wish to amend it? I'm sorry.
I had already said I amended it, and now, see, I'm starting to repeat myself over and over.
Yeah, okay. I'll repeat it again. Okay. We wish to create an RFP for a Title 32 attorney for day-to-day operations of the board and the district that is responsive. You want it only to the board. Is that correct, Mr. Baker?
Yes.
Okay. And so you do not wish to amend it? Yes?
Yes, that's my question to Director Baker. Are you willing to amend it so that the word only is removed?
I guess, who do you want this attorney to report to, Rhonda? Who's gonna be in charge of, wait, let me finish, please. Who does this attorney report to? If this is the case, then this should just all go away and let Joe run the entire operation. I think that's kind of where you're at on this thing. And you know what? I understand parts of this. I don't wish to jeopardize anything to do with the litigation. I'm listening to what our attorney's saying. I know that there are other issues that, quite frankly, I wish there was some way to address these. I think we have tried. I think people have, they probably haven't had the luxury of sitting in the executive sessions and these things where we have tried to talk to the attorney. If there was some way to heal this, I'm all for it. I'm all for it. But everybody sitting in this room knows what's going on. And you can say what you want. You also know what's at stake here. And I'm all for, if I had to withdraw this, if there was some way we could fix this, I'm for that. But we have been trying to fix it all along. Now, if somebody has a better idea, I'm all for it. And I will withdraw the motion.
So my request was not to withdraw it, but just to remove the word only. And the purpose is to, and I feel that as we put out the questions in the RFP, we can look at each individual, both within Joe's firm, outside of Joe's firm, to achieve the goal that we're seeking. I don't want to impact Joe, and I also want to solve some of the problems as well. And so I'm trying to come up with a solution that would respond to Joe's concern while also responding to the concerns that have brought this about to begin with.
Director Peters, burr me once, shame on me. Burr me 15 more times.
So I'm not okay with adding or removing that language.
All right. I think that we've discussed this to death. I would like to proceed to a vote. Is that acceptable with everyone?
Yes, ma'am.
Okay, thank you. Okay. Now, Mr. Plotkin, how do you vote?
I vote yay.
Mr. Baker, how do you vote?
I vote yay.
Miss Morgan, how do you vote?
Yay.
Yay? Yes?
In favor.
In favor. Okay. Miss Peters, how do you vote?
I abstain.
Okay. How do I vote? I vote nay. Okay. So, so we have 3 votes in favor. That will be Karen Morgan, Jeff Baker, and Alex Plotkin. Rhonda Peters abstained. Adrian Hannigan voted nay. Okay. So now we can move on to item B. Is that correct?
Yes.
All right. Okay. Miss Peters, could you do me the favor of taking over? I need to depart for a few minutes.
Sure.
If you could, I really need to leave. Okay, thanks. Excuse me.
So this topic has come up
And with
is
that,
an
folks,
important part of the settlement discussions. I'm very focused.
for those of you who are still following along at home, thank you. I've been in and out of this meeting. I'm going to spare you the last 1 hour of the meeting as I have other things to do and cannot monitor the ending of this video. I do want to thank you for joining us. The rest of the hearing can be found at this location. We are at the 2 hours and 34 minute 55 seconds of meeting. I hope that this has been an educational video for everybody who listened. To start with a process of, we're telling our government what they're doing wrong. In this case, the government is a board of directors that are elected to manage the public utility, Green Mountain Water, and Sanitation. The situations of bad intergovernmental agreements with third parties is more of what's to be discussed in this another hour of audio that is available again on the Green Mountain Water website. I have posted the direct link. This is the website link. And I hope that you found it interesting, enchanting, enlightening, and that you will join us again next time for another informational presentation. Have a wonderful day. Thanks for joining me. I'm your host, Brian Loma, aka Cut the Plastic, your water defender. Have a great day.